Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. We're coming to you from Washington's nicest indoor shooting facility, of course, that being Security Gun Club right here in Woodinville, Washington. But I want to talk to you yet again about an issue that we've been pretty passionate about here at Washington Gun Law. And it deals with this strange anomaly that, chronic alcoholics, the type of people who are basically drunk 24/7, as long as they can get themselves sober enough to get to a gun store, they'll be able to purchase a gun. Or pill poppers, people who perhaps have all prescriptions from it, but they are essentially a DUI in perpetuity because they're so strung out on a cocktail of prescription medications. But you know what? They have no problem walking into a gun store and purchasing a gun. But God forbid if you smoked a joint once a month or something like that. Because if you do that, then we know that federal law says, oh, no, you are an unlawful user of a controlled substance and you cannot own a firearm. Well, you know what? We've seen the Fifth Circuit of the United States Court of Appeals lately take a wrecking ball to a lot of other what we thought were well-established gun laws, and today's video is no exception. Because the Fifth Circuit has once again taken an absolute wrecking ball to this prohibition against cannabis users and the ability to possess a firearm. So today, let's spend a few minutes and let's talk about how the Fifth Circuit just stoned another federal gun law. Okay, so the case we're talking about today is a case called United States v. Daniels. It's the first time that we've covered this case. Mr. Daniels was pulled over by law enforcement that happened to have DEA officers. They found him in possession of a firearm, or I believe a couple of firearms. There was also evidence that marijuana had been recently consumed in the car. During interview, Mr. Daniels then admitted that he was a relatively regular user of marijuana, and also, since he was in possession of firearms, was then convicted under 18 United States Code Section 922G3, which of course makes it unlawful for anybody who is an illegal user or addict of a controlled substance as defined by federal law to be in possession of a firearm. Now, since post-Bruin, we have been doing kind of a soul searching, if you would, on many gun laws. We're going to take a look next summer at whether or not pretrial conditions of release, which require forfeiture of firearms, is even appropriate in the matter of United States v. Rahimi. And we're beginning to see more and more reanalysis of pre-existing gun laws. The court, which has absolutely shown the greatest willingness, almost eagerness, if you would, to go out and re-examine these gun laws, of course, is the Fifth Circuit. And they have, in fact, re-examined a case that was previously ruled in favor for the United States of America on this case, on summary judgment. However, the matter was reopened, relitigated under the new correct standard of law as applied in Bruin, and we now have ended up with a vastly different decision because the Fifth Circuit has, in fact, found that 18 U.S.C. Section 922G3 is unconstitutional. This is how the court begins this very lengthy analysis. The question is whether Daniels' conviction violates his right to bear arms. The answer depends on whether Section 922G3 is consistent with our nation's historical tradition of firearms regulation. It is a close and deeply challenging question. But, and this is the most important thing, and we did this video right here, which actually talks about some pretty productive rulings that come out of the Ninth Circuit recently, and that is shockingly, when we apply the correct standard of review to any of these ridiculous gun control pieces of legislation, we come to the correct conclusion each time, as the Fifth Circuit put it. In short, our history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug usage. Nor do more generalized traditions of disarming dangerous persons support this restriction on non-violent drug users. As applied to Daniels, then, Section 922G3 violates the Second Amendment. We reverse the judgment of conviction and render a dismissal of the indictment. Now, as you can imagine, the United States government offered several arguments, most of them in desperation, as to why this law should still stand its constitutional scrutiny. Predominantly, their arguments were, well, there's a long, rich tradition of disarming people that we deem to be dangerous. And yes, they pulled out the Catholic card again. And they also predominantly talked a lot about many of the restrictions, Washington State included, that has a restriction on being in possession of a firearm while you are under the influence of an intoxicating substance. Those same arguments were actually used previously to reach a verdict in favor of the United States government, but that was done under the old standard. And as the Fifth Circuit pointed out, nevertheless, assuming that Daniels had a right to bear arms, the court found that 922G3 was a long-standing gun regulation. It compared 922G3 to laws disarming felons and the mentally ill that Heller called presumptively lawful. The district court placed weight on that regulatory tradition. It engaged with few historical sources from the founding or Reconstruction, but it relied on statements from other courts, notably all predating Bruin, that 922G3 was supported by the historical practice of disarming those who exhibit a dangerous lack of self-control. And as they pointed out, that of course was under the previous two-part analysis. But as we know now, under the new Bruin analysis, it's pretty simple. We take a look at the activity and we ask ourselves, does the plain text of the Second Amendment cover it? If the answer is yes, the law is then presumptively unconstitutional, and the government must then advance a historical analog that shows that we as a country accept that sort of regulation. If they fail in their burden of proof of doing that, then the law remains presumptively unconstitutional and shall be struck down. Now, of course, one of the arguments that the government advances is, the right to keep and bear arms only applies to lawful citizens. And since Daniels, of course, is a pothead, he is not a lawful citizen and therefore does not enjoy those constitutional protections. The Fifth Circuit was not persuaded. The right to bear arms is held by the people. That phrase unambiguously refers to all members of the political community, not an unspecified subset. Indeed, the Bill of Rights uses the phrase the people 5 times. In each place, it refers to all members of our political community, not a special group of upright citizens. Based on that consistent usage, Heller concluded that the Second Amendment right is exercised individually and belongs to all Americans. Even as a marijuana user, Daniels is a member of our political community. Therefore, he has a presumptive right to bear arms. By infringing on that right, 922G3 contradicts the plain text of the Second Amendment. And one of the arguments, of course, that we begin to see is, yes, but we were talking about lawful, responsible, law-abiding citizens, and Daniels has already said he is not one of those. But the court, again, further pointed out, but we cannot read too much into the Supreme Court's chosen epithet. More than just model citizens enjoy the right to bear arms. Indeed, in Rahimi, it held that citizens accused of domestic violence still had Second Amendment rights. It reasoned when Heller and Bruin used the phrase law-abiding, it was just shorthand to exclude from the discussion the mentally ill and felons, people who historically were stripped of their Second Amendment rights. Now, with the Fifth Circuit obviously deciding that this activity was covered by the plain text of the Second Amendment, it became the government's burden to establish some type of a historical analog. And what did they come up with? Well, they came up with 3 of their more traditional arguments. 1, statutes disarming intoxicated individuals. 2, statutes disarming the mentally ill or insane. And 3, statutes disarming those adjudicated as dangerous or disloyal. And really what the court found is that of all of these, the only one that has some mild similarity is the prohibitions on carrying firearms while intoxicated. As the court put it, because there was little regulation of drugs related to guns or otherwise until the late 19th century, intoxication via alcohol is the next closest comparator. Unfortunately for the government, that regulatory tradition is sparse and limited during the relevant time periods. Despite the prevalence of alcohol and alcohol abuse, neither the government nor any amicus identify any restrictions at the founding that approximate Section 922G3. Although a few states after the Civil War prohibited carrying weapons while under the influence, none barred gun possession by regular drinkers. And again, they make this argument over and over and over. And there are many, many states, my state included, that does have an absolute prohibition on possessing a firearm while you are actively under the influence of any type of impairing substance. But as the Fifth Circuit pointed out, beyond that duet of colonial regulations separated by over a century, the government identifies no founding era law or practice of disarming ordinary citizens for drunkenness, even if that intoxication was routine. The Fifth Circuit also pointed out, Given the prevalence of drinking at the founding, that handful of laws puts the government on shaky footing. The government has failed to identify any relevant tradition at the founding of disarming ordinary citizens who consumed alcohol. Any later laws, of course, were no help to the government as well, as the Fifth Circuit pointed out. The government's Reconstruction era evidence, though stronger, still falls short of the history and tradition that could validate Section 922G3. And what they are looking for here, and this is a really important kind of two-part test here, is when we're trying to determine the appropriateness of a historical analog, what the court is saying is we need to look at two things. We need to take a look at the why was the law created, and number two, how. How was the law effectuated? What did the law actually do? And where it falls apart on these laws as it relates to being intoxicated by alcohol for the United States government is the court basically says, listen, the why. Why do you do this? They are similar. Yes, people who are impaired have less judgment than if they weren't impaired, and bad things can happen when they're armed. So the why is similar. The difference is the how, because when we talk about people who are intoxicated by alcohol, the how is you cannot possess the firearm when you are actually intoxicated. But the how for marijuana users is you can't possess a firearm ever, even if you only smoke cannabis for medicinal reasons on a sporadic occasion. There is no other point in your life, however, where the United States government believes that you should be allowed to exercise an otherwise inalienable right. The government's argument about, well, what about our prohibitions against those that are mentally ill? Well, again, the Fifth Circuit pointed out, yeah, because when you can establish that they are actually in a state of mental illness, they are in fact unfit to possess a firearm at that current time. But as the Fifth Circuit put it, still, that comparison could justify disarming a citizen only while he is in a comparable state to lunacy. Indeed, it is helpful to compare the tradition surrounding the insane and the tradition surrounding the intoxicated side by side. The founders purportedly institutionalized the insane and stripped them of their guns, but they allowed alcoholics to possess firearms while sober. And ultimately, the mere fact that the government thinks that you, for whatever background reason might be, makes you dangerous to possess a firearm, well, the Fifth Circuit pointed out that's not really part of the inquiry, as they put it. That said, no one piece of historical evidence suggests that when the founders ratified the Second Amendment, they authorized Congress to disarm anyone it deemed dangerous. Instead, the government collects different statutes disarming discrete classes of persons at various points in history. Those laws suggest an abstract belief that an individual's right to bear arms could be curtailed if he was legitimately dangerous to the public. And of course, in addition to talking about all the drunkards and how we could restrict firearms for them, let us not forget that the government has another favorite playbook they like to go to, and that, of course, is the disarming of Catholics, as the Fifth Circuit, however, characterized it. Furthermore, even as the founders were disarming Catholics and politically disaffected citizens, they left ordinary drunkards unregulated. The government has no meaningful response to the fact that neither Congress nor the states disarmed alcoholics, the group most closely analogous to the marijuana users in the 18th and 19th centuries. As with the government's analogy to mental illness, we must ask, which are marijuana users more like? British loyalists during the Revolution or repeat alcohol users? The answer is surely the latter. Listen, this is a huge ruling out of the Fifth Circuit. Now, this comes from a 3-judge panel of the Fifth Circuit, and it is likely going to be appealed to an en banc panel of the Fifth Circuit. However, if you're the United States government, you realize that, well, you have not had a particularly good year in front of the Fifth Circuit, especially as it relates to Second Amendment issues. The case, once again, is United States v. Daniels. We're going to link it up down below so you can read it for yourself. We're going to closely follow this. This is an issue that we really strongly believe in here at Washington Gun Law. We happen to be in a legalized cannabis state here in Washington State, and shockingly, as bad as this state sucks, and it does, we have not come unraveled at the seams because of our legal cannabis industry. I do believe that cannabis should be regulated in a similar fashion as alcohol, and I do believe that the rights of individuals to engage in the act of self-preservation should be the same as for cannabis users, recreational or medicinal, as it is for alcohol. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. Now, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.